Good afternoon. Happy Wednesday. Look, it's my beautiful face. So, Chili requested that Google waive notice and Google waived service. Excuse me. And people think that that's somehow odd or weird or unusual. And that's entirely not odd or weird or unusual. It's in Federal Rules of Civil Procedure 4, probably. But you have a duty. If someone says, hey, waive service, you have a duty to waive the service and say, hey, sure, I will send this to you saying that I have been served now. I'm waiving service. I have my summons, my complaint. We're good. Let's get this ball rolling. Because you've got to remember, the point of serving someone is to make sure that they have been served. Make sure they have notice of the hearing, because you have a right to notice and an opportunity to be heard, right? So anyway, Google had a duty to do that. And if they didn't do it, then Chili would have had to serve them the old-fashioned way, have someone go down to their agent for service of process and hand them the paperwork and bada boom, bada bing. But Chili would be able to pass that cost along to Google. Google would be responsible for that cost. So Google probably doesn't want to pay the 80 to 150 bucks or whatever it is to have them served. And so they agreed to waive service. Now, as a bonus for waiving service, instead of having only 30 days to respond to the complaint, they have 60. So that's a pretty standard thing. California has a statute that does essentially the same thing. You send out a notice and acknowledgement of receipt. If they sign it and return it, saying that they've received everything, then you're good to go. If they don't sign it and return it, then you have to serve them the old-fashioned way, and they're responsible for the costs associated. Easy peasy, lemon squeezy. This is document 99, I think, is their notice of waiver. So, and Chili filed it. I don't know why it took so long to file it, because apparently they got it on December 3rd. So it seems like he waited 30 days to file it. Maybe he's just behind the ball a little bit. So what's going to happen next? I'm going to assume that what happens next is a massive 12b6 motion. It's going to be very well written. It's going to state multiple grounds. The terms of service ground, i.e. that they agreed to service in, or they agreed to be sued, and he agreed to sue them in the federal district court for, was it Northern District of California? Or Central? I don't remember which. But anyway, they certainly didn't agree under the terms of service to be served and sued in the District of Massachusetts. So that's going to be in there, somewhere in there. I'm assuming they're also going to do the Section 230 safe harbor things, that they complied with it, that he agreed in the terms of service to allow them to host these videos, and that they're not the publisher of it, and that they have done everything required under the Communications Decency Act to make sure that his copyrights were protected. I'm sure they'll have other things that I haven't thought about. I'm not a copyright attorney. I'm sure they have one. I'm sure they have a bank full of responses of 12b6 motions. A motions bank is a really fun thing. If you ever have access to one, they're pretty cool. Prosecutors' offices will have motions banks, because all they do is criminal, right? And so they have all the same kind of motions that are done over and over and over again. And so they just have like fill in the blanks motions. You fill it out. And it's already got the case law and everything like that. It tells you what to put in where. I mean, they're cool. You'll see public defenders will have those. Major law offices that deal with a very specific subset of cases, like law offices that represent insurance agencies and personal injury cases, will oftentimes have motions banks. And I'm sure that a massive corporation like Google, who deals with idiots filing copyright lawsuits all the time, will also have 12b6 motions just prepped and ready to go. Just fill in the blanks. hit print, and you're off to the races. So I don't anticipate Google being in there much longer. I assume that they're going to file their response pretty close to the end of their time window, just to see if it gets dismissed for whatever reason. They don't have to respond. They'll probably file it at the end of January, beginning of February, and then they'll be rocking and rolling, and he'll have 14 or so days to respond to their 12b6 or so, and then the judge can make a ruling on it pretty much any time after that. So best case scenario is that case goes bye-bye, at least as far as Google is concerned. YouTube, best case scenario is they're out of there by the end of February. So I mean, it could happen quick. Anyway, I've rambled long enough. Thanks for watching. Have a great day.